On the record in the matter of the people. Let's see. On the record in the matter of the people of the state of Michigan versus James Edward Jones, file numbers 22-03029 and 22-03034. Council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Dan Doe appearing on behalf of Mr. Jones, who's present to my right.
Thank you. Today was the date that we set to continue this examination so that we can have further testimony from an officer. Are we ready to proceed on this?
Yes, Your Honor.
Any preliminary matters?
Not from the people.
Not from the
Okay, for your witness.
People would call Officer Jason Murdoch. He's the responding officer in file 22-3034.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
Thank you. You can have a seat, sir. Sorry, it's a little tight. New courtroom's coming soon, I hear. Please state your name, spell them both.
Jason Murdoch, JASON MURDOCK.
You can proceed, counsel.
Thank you. Morning, Mr. Murdoch.
Morning.
Where are you currently employed?
City of Lansing Police Department,
And what's your role there?
police officer,
Officer Murdoch, how long have you been a police officer?
total 15 years.
15 years. Were you working in that capacity on August 29th of 2022?
Yes,
And on that day, did you respond out to 6208 Rosenberg Road?
yes,
Did you make contact with a Minnie James?
I did.
Is that in Lansing?
It is.
Is that in Ingham County?
Yes,
Did you speak with Miss James?
I did.
Now, did you discuss with her an assault that had taken place?
I did.
Did you observe any injuries on Miss James?
I did.
And what were those injuries?
She had a scratch to her neck, and then she complained of discomfort in her ribs.
And did that seem to match what she had told you had happened?
Yes,
People, no further questions to this witness.
Prosecute.
Yes, Your Honor. Thank you. Morning, Mr. Murdoch. My name is Dan Doe. I represent Mr. Jones. Just got a few questions. So that day, you did not see anything that would have constituted an assault. Is that right?
no, I saw the injuries that day, or at least to the neck, I saw the injuries.
And you compose a report
I
about
did.
this. And but did you indicate in your report that there was no visible injuries?
I indicated in my report reference to the discomfort in the ribs. I did not observe it.
And you interviewed Ms. James. Well, after you interviewed Mr. James, did you take pictures?
I did.
Did you take pictures of her neck area?
I did.
Your Honor, may I approach the witness?
Okay.
Officer Murdoch, do you recognize that?
I do.
What is that?
These are the photos that I took that day.
And are those a fair and accurate depiction of what you observed that day?
I'm sorry.
Would that be a fair and accurate depiction of what you observed that day?
So yes, you got a photo of a tip that day.
Your Honor, I handed the officer defendant proposed exhibit A and B. I would make a motion for admission. Is that it?
Any objection?
No objection from the people, Your Honor.
The defense exhibits, were they marked?
A and B.
A and B are admitted without objection.
Just a few more questions. Looking at those pictures in front of you, can you identify any injuries on the photographs?
They're not as clear in the photographs, but what I saw.
But you're seeing scratches.
Yes.
Can you tell how fresh the scratches were? Or
They appear to be pretty fresh.
can you, and where were they located?
If I remember correctly, it was along the right neckline, like coming across. They appear to be fairly fresh within, a couple hours between when I got caught there and when she said it was perfect.
But the record just reflects that the witness made a motion dragging his fingers from below his ear on the right side of his neck down to the middle of the neck by the trachea.
So noted.
Would you offer Ms. James any medical attention?
I believe I did, and she refused.
And I don't have any other questions.
No, Your Honor.
You publish the photos.
Yes.
Okay, next witness be excused.
Yes, Your Honor.
Thank you, Officer Money. You can call your next witness.
Yes, Your Honor. The people call Officer KL Fombi, and I'm probably mispronouncing that first name. And he is the responding officer, file 22-3029.
Can you raise your right hand?
So you gotta face the judge.
Okay, thank you. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Thank you. You can have a seat there. Please state your first and last name and spell them both.
Officer Mikael Fombi, Mekayle. Last name Fombi, Fomby.
Please proceed, counsel.
Thank you. Good morning, Mr. Fombi.
Morning,
Where are you currently employed?
Lansing Police Department,
What's your role there?
another patrol officer.
So, Officer Fombi, we work in that capacity on October 6, 2022.
Yes,
And on that date, did you go out to 6212 Grovenberg Road?
yes,
Is that in Lansing?
yes, sir.
Is that Name County?
Yes, sir.
And why'd you go out there?
We were dispatching 911 call for a female named Minnie Jones.
Did you make contact with Minnie James?
I did.
You talked with her?
Yes, sir, I did.
Did you determine that an assault had taken place?
I did, yes, sir.
Did you observe any injuries to Miss James?
I did.
And what were those injuries?
When she came outside, I obviously noticed the right side of her face was swollen and red. And that's what I observed. It's a swollen face on the right side of her face. It's really swollen and obviously a little swollen.
Did that seem to match what she had told you had happened?
She did.
Now, Officer Fombi, when you spoke with her, were you outside, inside a residence?
I was outside the residence in the driveway.
And was Miss James holding a child?
She was.
Your Honor, at this time, people have no further questions for this witness.
Cross-examination.
Yes, Your Honor. Good morning, Officer Bobby. Okay.
Yes, sir. Yeah.
All right, my name's Dan Doe. I represent Mr. Jones. Now, when you went to the residence, was it day or night?
It was daytime.
And then you observed Ms. Minnie Jane.
Correct. Yeah.
And when you observed her, was she wearing an arm brace?
She was.
And did you inquire to her why she was wearing an arm brace?
I did not. I did not recall.
So you don't know if she was injured before or injured. You have no way of saying how she was injured. Exactly.
Correct. As far as I can.
Did you offer her medical attention?
I did. She refused.
And you were there solely for domestic assault, is that right?
Correct.
That's all, Your Honor. I have no more questions on this file.
Any reader.
None, Your Honor.
You may be excused, Officer Bombi. Any additional prosecutorial witnesses?
No, Your Honor. People rest. Both files.
Thank you. Mr. Gibbons, call any witnesses?
No, Your Honor, thank you.
You can proceed your argument.
Yes, Your Honor. I'll start with file, the earlier one chronologically, 223034 FY, of Officer Murdoch. This is the one that occurred on August 29th, 2022. I believe that sufficient factual basis has been laid based on the testimony and the evidence presented for counts 1, unlawful imprisonment, 2, assault intent to do great bodily harm, less than murder or by strangulation, and count 3, domestic violence. Body camera footage showing the statements that the victim made to the officers was admitted into evidence, and it was admitted under MCL 768.27C. It's not only on the record for impeachment, it is on the record as substantive evidence, which needs to be taken as such. I'm not questioning the officers about what they told you, because there would be needlessly cumulative at that point, because that evidence is already on the record. We heard victim tell the officers was free to leave. Tell the officers he held her there, wouldn't let her leave. He did so in order to strangle her. We heard them tell the officers difficult for her to breathe. All the elements have been met for a probable cause standard. However, the people are requesting an additional count in this file, 223034. That count being interfering with a witness in a criminal case punishable by more than 10 years. Cat code for that being 750.1227B, B as in boy. As we heard testimony from Officer Wanacott and the actual jail calls that were played between the defendant and the victim, where he's telling her, I don't know why my attorney is telling you to come to court. He's wrong. You need to make these things disappear. You need to be like a magician. You need to make sure they can't find you. If you show up, then I'm fried. You're going to have to explain to our son why their dad's in prison. Over and over again, yelling at her, commanding that she do what he says, do what he wants. And he makes it incredibly, inescapably clear that he wants her not to come to court. Because of that, Your Honor, the elements for MCLs, the elements for an added count 4 of witness interference in a criminal case punishable by more than 10 years have been met, and I'd ask that you add it. And further, I would note, when we were here previously in this case, the defendant already admitted out loud to contacting the victim. From there, I'd like to move on to file 22-3029FY, the incident that occurred on October 6, 2022 with Officer Mikhail Fomby. Once again, body camera footage has been entered into evidence, admitted under not just for impeachment, but our MCL 76827C as substantive evidence. In that case, he's charged with interfering with a crime report by committing a crime or threatening to kill or injure misdemeanor domestic violence. In that case, we heard the victim tell the officer that he threatened her. He threatened to kill her. And he's going to beat her, saying she can't call the police. For a probable cause standard, the elements for count 1 have been met. And I'd like to find it over as such. Further, I'd ask for another added count. Same thing. Witness interference, criminal case punishable by more than 10 years. MC Hack Code 750.1227B. Because the same conduct applies, and it does equate to criminal charges in each file. As she was set to come to court in an official proceeding as a PE for file 22-3034. She was also set to appear in this court and testify in an official proceeding, preliminary exam for file 22-3029. He told her not to show up to either. Because of that, these are multiple separate instances of witness interference because there are multiple separate official proceedings that he's telling her not to appear for. As a result, it is appropriate and necessary for a count to be added in each file. I'd ask that you add them as such, bind over with those additional counts. Thank you.
You're asking to add witness interference. Who's done? Right. Interfering with a witness in a criminal case, correct?
Yes, the one that's punishable by more than 10 years.
Mr. Doyle.
Yes, Your Honor. Thank you. In discussing the first file, first, the allegation of unlawful imprisonment and assault with intent. Ms. James, here, she testified under oath. She unequivocally denied that there was no assault, that she was not unlawfully imprisoned in any way, shape, or form. She testified that she lied to the officers and she gave a reasoning why. I do believe that would suggest that this never happened. Even for a probable cause standard, we're looking at what the officers observed her on the day of their body cam versus what she's testifying under oath under her. So I would ask that you not bind over on those files. Now, counsel wants to add the witness interference. That would require evidence that Ms. James was actually going to testify and was actually going to testify. We have any testimony that she was not going to testify. She was here. She came in and she testified. So that should deny that added count. And specifically, I asked her, did you ever tell her not to testify? Which she said no. Now, moving on to the next file. MCL 7504838-2B would require some threat to injure or kill. I don't believe that was ever placed on the record, and she also testified unequivocally that she was never threatened or she was never threatened. She was never threatened or an attempt to retaliate against another for having to report or attempted to report a crime being committed or attempted to be committed. That wasn't placed on this record. I don't believe so. As such, I would ask that you not bind over on that file. And not bind over on the requested added count for the same reasons. That's all, Your Honor. Thank you.
I'm going to respond briefly, Your Honor.
Okay.
The victim was here doing exactly what the defendant wanted her to do. Once he learned that I could do this without her, he was calling her, telling her not come to court. Then he fired Mr. Feigelson. Before he left, I put on this record to make the defendant aware that I can do this without the victim. I have a history of getting bind over without the victim, and the court affirmed that. And then it changed to, I just got to get here and say it didn't happen. It's clear she was not being honest with this court. She said things that contradicted themselves and that were blatantly disproven by the body camera footage that was admitted in each file. First said, oh, well, I just wanted to get out of the house. I wanted to get out of the house with my kid. Except she had been out of the house with her child when she spoke to police in each incident. Body camera showed she was out of the house, away from him, holding the baby when she said these things. She didn't have an answer to that. Changed from, well, he doesn't want me there to, he wants to keep me there. She flat said she felt she had to call the police because her baby's father, the defendant, wouldn't like it if she tried to leave. She felt she had to call the police to get out of there. Further, that is why the domestic violence hearsay statute exists. I can actually quote the Senate arguments for the matter. Similarly, when a victim makes a statement about a domestic abuse incident to police, the later recants or refuses to appear at court, the testimony of the law enforcement officer regarding the statement made to him or her should be admissible. Otherwise, an offender, his or her control over the victim, may have the power to determine what evidence is or is not presented to the jury. That's the Michigan Senate's arguments when they were discussing this exact statute being passed, which they did. We did hear testimony about the defendant threatening her in the body camera. She informed the officer that Mr. James told her, oh, you're on the phone with police? Then I'm really about to beat your ass. Which would absolutely meet the elements necessary for interfering with a crime report by committing a crime or threatening to kill or injure. We heard him say on the calls, you can't come to court. Don't come to court. Why is my attorney telling you to come to court? You need to do what I'm telling you to do. My life is on the line. If you come to court, I'm really fucking fried. And we heard he did this before. With that quote, bitch India, unquote. And he knows the prosecutors don't listen to these calls because he did this when he wasn't here with the last domestic violence victim. He called her, told her not to come to court, and she didn't. It got dropped. He was telling this victim in these calls to get these charges dropped, to keep calling them to get it dropped, to not come to court. He clearly committed the crime of witness interference. And contrary to what Mr. Doyle is saying, it doesn't matter that she came to court because the statute only requires that he attempt to interfere with her coming to court. Not that he succeeds, not that he doesn't change his mind later, that he attempts to get her not to come, which he unequivocally did for each file. It's clear that she was doing what she felt she had to here today. I even asked her, do you want him out of jail? Yes. Why do you want him out of jail? And she went on for about 5 minutes about the financial assistance he provides to her and the child, the support that he provides able to take care of childcare off her plate. She didn't once say he didn't do it when I asked why he should be released from jail. Because it's not about the fact that he's innocent, because he's not. She was here saying what she said because she relies on his financial support. The evidence is clear in this matter. I'd ask that you bind over as charged and add the 10-year witness interference to each file. Thank you. Further, Your Honor, in case it is an issue with the court, the file 23029, because I'm asking for the witness interference in a crime punishable by more than 10 years. Count 1 is normally a 10-year felony. However, as an habitual offender, the maximum for that is now life, which allows for the 10-year witness interference to be added to that file. Thank you.
There was a date that was set to conclude the preliminary examination, which began back on February 9th. At the time of the preliminary examination, the burden is on the prosecution to establish that they have sufficient probable cause in each matter to charge you with the crime, and it's probable cause that you were the person that committed the crime. And it's a flexible standard. It's based on facts and circumstances presented at the hearing or the preliminary examination. The court is the sole determiner of credibility at this time, and I have to weigh the probability of the government's ability to establish guilt at trial. And so it doesn't require as much evidence as it would be required to prove your guilt beyond a reasonable doubt at trial. Today, the burden is more than mere suspicion that a crime was committed. And so we've had testimony here, and we've had some exhibits. We had several videos played of body cam and jail calls. Taking first file number ending in 22-03029. Here is, let's do that one first. It's August 29th file. Okay, taking file first ended in 3034. This is the incident that allegedly occurred on August 29, 2022 at 6212 Rodenberg Road, City of Lansing, Ingham County, State of Michigan, making venue in this court appropriate. We heard testimony of an alleged victim, Minnie James, and she identified the defendant as the father of her child. She indicated that she, on that date and time, did contact law enforcement due to a situation that occurred at that address, and that she was at certain points lacking a lot of remembrance or recollection when questions were being posed to her. In order to help refresh her recollection, the people did produce video evidence, also admitted under 27C, in which the victim spoke with the officers at the address alleged, indicating that she had been assaulted by the defendant and that she wanted to get her child or her baby. And that the defendant put his hands on her, punched her in the ribs, and hit the baby in the legs when trying to attempt to punch her. She described other areas or incidences of physical contact during that time, including the time in which she attempted to vacate and he grabbed a gun. So she states to the officer, she stated at the time to the officer that she had been repeatedly punched in the ribs and that the defendant punched her in the face. The defendant's mom was present but was sleeping, and that she cried or screamed for the defendant's mom to help her. The defendant then grabbed or gripped the victim around the neck and slammed her on the couch. while she had the baby in her arms. She told the officers that she was balled up on the couch while the defendant attempted to snatch the baby out of her hands. Count one, unlawful imprisonment. To prove that at trial, the people would need to prove beyond a reasonable doubt first that the defendant knowingly restrained another person. Restrain means to forcibly restrict a person's movements or to forcibly confine the person so that to interfere with the person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, the defendant did so under one of more of the following circumstances. A, the person is restrained by means of a weapon or dangerous instrument. B, the restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret. Or C, the person was restrained to facilitate the commission of another felony or facilitate flight after commission of another felony. Defense argues that the victim appeared and that the victim stated either that these incidences did not occur or that she did not recollect these incidents occurring. I didn't find the victim's testimony to be credible at all. She indicated when questioned that she wanted the defendant home because he financially provided for her, but in viewing her body language and demeanor during the court proceedings in light of the video evidence, as well as the evidence that was later presented to support the jail call or the violation of the bond circumstances, the court is inclined to believe the testimony of Ms. James was uncredible. And for that purpose, the court is relying heavily upon the body camera evidence that was presented to help refresh Ms. James' recollection. With that information, without rehashing the testimony presented through that evidence, the court is satisfied that there is sufficient probable cause as to count one, unlawful imprisonment, based on either A or C. The person is restrained by means of a weapon, that there was an allegation of a firearm used during the commission of the alleged assault, and or C, the person was restrained to facilitate the commission of another felony or to facilitate flight after the commission of another felony. So count one will be bound over to the circuit court. Count two, assault with intent to do great bodily harm, less than murder or by strangulation. As heard on the testimony through body cam, that is, there was countless statements made to the officers that the defendant on that date and time placed his arms around Miss Minnie James' neck. At one point, she was punched in the face, punched in the ribs. That the defendant grabbed and gripped her by the neck and slammed her on the couch. At the time of trial, that people would need to prove beyond a reasonable doubt the following elements. First, that the defendant tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believe that he had the ability. And third, that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. I ordered the officers that appeared here today before the court primarily because of my belief that the testimony provided by Ms. James was not credible. We have Officer Jason Murdoch that appeared or responded to the incident on August 29th, and he testified here under oath that he observed scratches to the alleged victim's neck on the date of the incident, and that she complained of discomfort to her ribs He stated that those scratches appeared fresh. He took pictures of the defendant's, or I'm sorry, of the victim's neck and her ribs. That's presented here in people's exhibits, I'm sorry, defendant's exhibits A and B, although not necessarily visible to my eye from these pictures. He indicated very clearly that he saw what he saw, which was injuries to her neck. And so based on that testimony, the court is satisfied that there's sufficient evidence as to count 2, assault with intent to do great bodily harm less than murder, or by strangulation, that will be bound over to the circuit court. Count 3, domestic violence, habitual offense, 4th offense notice, the mandatory 25-year sentence will be bound over as well. The testimony was that they were in a dating relationship. They had a child in common. That was bound over as well. And the other file we have, what there was a request to add count 4 to that file, interfering with a witness in a criminal case. And that was based on the jail calls, which were played at least in part for the courts. To prove interfering with or intimidating a witness in a criminal case, penalty more than 10 years, that people would need to prove beyond a reasonable doubt at trial that the victim, in this case, Minnie James, was an individual who was testifying or going to testify or going to provide information at an ongoing or future official proceeding. An official proceeding is a proceeding heard by a legislative, judicial, administrative, or governmental agency or official authorized to hear evidence under oath. Second, that the defendant tried to intimidate Ms. James. A threat is a written or spoken statement that shows an intent to injure another person or that the person's property or family. No particular words are necessary, and it can be said or written in vague terms that do not exactly or state exactly what injury will occur, but it must be definite enough so that the person of ordinary intelligence would understand it as a threat. Third, that the defendant threatened or tried to intimidate Ms. James, and that he intended to discourage Ms. James from attending the proceeding, testifying at the proceeding, or giving information at the proceeding, or influence Ms. James to testify at the proceeding, encouraging Ms. James to avoid legal process, withhold testimony, or testify falsely. It does not matter whether the official proceeding took place, as long as the defendant knew or had reason to know that Ms. James could be a witness or was going to provide information at the ongoing or future proceeding. Fourth, that the official proceeding was a criminal case charging a crime with a maximum punishment of more than 10 years or life in prison. I've heard the jail calls, and we've had Mr. Pfeiffer reiterate quite succinctly and accurately the statements made by the defendant on the jail calls after he had been told and admonished multiple times not to have contact directly or indirectly. And those jail calls, in my belief, were for the purposes of intimidating and or encouraging or discouraging Ms. James from appearing in court to testify truthfully while under oath. And so the request to add count 4, intimidating a witness in a criminal case, is granted. File number 22. Dash 03029. There's a count 1 of interfering with a crime report incident allegedly having occurred back on October 6, 2022. also at the address of 6212 Roving Bird, City of Lansing, Ingham County, State of Michigan, making venue appropriate in this court. Again, we have a witness, Miss Minnie James, who the court found lacked credibility during providing her testimony. Officer, I'm sorry, the prosecutor had to play the officer's body cam to refresh portions of her recollection. I also request to have that admitted under 27C. In viewing the body cam, we see where the victim told or reported to the officers that appeared the defendant had beat her over someone texting her, and that another man called her phone. Officers noted that there had been 3 prior domestic reports involving the parties. The victim stated that the defendant smacked her, punched her, drug her with a mop stick. Officers noted swelling to the victim's head. Officers noted scratches to her neck. I ordered Officer Bombi to appear today to provide further testimony as to the observation of any injuries to the victim. And he testified under oath today that he observed injuries to the right side of her face. Her face appeared to be swollen and red. As to count 1, interfering with the crime report, committing a crime threatening to kill or injure, Mr. Doyle has argued that there was no threat. However, the prosecution has reminded both the defendant and the court of the exact statements made or alleged to have been made at the time, which was that if you're calling the police, I'm really going to beat you, or something along those lines. And so there was an allegation of threat to injure in response to the perceived or perception that Ms. James was calling the police in reference to a domestic assault. And so count 1 will be bound over to the circuit court. Count 2, domestic violence, habitual offender will accompany that to the circuit court. There's a request to add a count to this one as well, interfering with a witness in a criminal case. And the basis for this request is that both matters were pending before the court with the alleged victim to appear to testify at the time in which those jail calls were made for the purposes of intimidating or interfering with Mr. James' testimony or truthful testimony before the court. The court is satisfied. We'll grant that request and is satisfied that we have sufficient probable cause to bind over as to that as well. Each matter will be bound over for a bind over date of March 29th. You do not need to appear in court on March 29th. That's the date that the circuit court gets to files from this court. Do you understand that? I'm talking to you. Use your words. Thank you. Okay, and so your next court date will be a pretrial. You and Mr. Doyle will be made aware of that date. You will not have another arraignment in the circuit court. Do you understand that? Use your words. Okay. Do you have any questions today?
Oh no, yeah, about my phone.
What about your phone?
They took my phone again. They told them I called them. I asked them like why my phone and my physical was cut off, and they said Canon order for me not to have them. I no ticket to call nobody, none of that. Like my judge gave me my phone, gave it back. Like, that was like in February, I think. And now when we moved to the new jail, all of a sudden they just took them again.
I don't see a note where Judge Buchanan came after me to take those. I do see where she revoked your phone privileges back in November. And I see in December where I said that you can make phone calls to your mom and to your attorney.
Yeah. And then just recently they just took them on last month, February.
There's no further notes in the court
February
record.
17th. I can't even call or nothing. And then I ended up asking them like, can y'all reset my phone? They were like, no. Per Judge Buchanan, you have no e-messages, privileges, or no phone privileges.
Okay. That's an old order. That was from November 17th. There should have been updated order in December.
But I ended up getting them back when you ordered me to get them. I ended up getting them back
So
again.
that's the latest order as it relates to your jail calls. We've not addressed jail calls since then. Unless I missed something. Is there another file I don't know about?
No, Your Honor. What I'm guessing happened is when they moved to the new facility, all they looked at was that order from Judge Buchanan before, and they missed the one from this court, reinstating them, at least in regards to his mother, his attorney.
Well, I'll make sure that they get the notice to reinstate your calls to your mom and to your attorney.
So I was just using my phone when we moved over there. Then, like they just,
It's probably something to do with the transition. They probably got something misconstrued because that's not our order at this time. Any additional questions?
Just 60 seconds. Your Honor.
Take your time.
I do see that Mr. James was able to call his mother on the 17th and the 19th, was not able to after that, and then started using the inmates of David Moore, Asia Williams, Amon Meyer, and then back to David Moore, which is the 15th in order to talk to her. Once again, he's using other inmate accounts. He's not supposed to.
Did you know that they got access to that?
I'm
information, right?
like, I'm like, because I believe that he had my phone records taken again. Like that's
Who's he?
the,
He doesn't have the authority to have your phone privileges taken. Only the judge can issue that. He has authority to listen to him, that's for sure. And he's gonna listen. If you haven't learned that now.
and then I feel like it's just like I can't even call my attorney and ask him like,
But your attorney should be talking to you on a private line.
I can't.
You mean you can't what?
I just feel like I'm facing some serious charges, and it's like I'm not like getting it. Like I feel like I should be able. I don't know.
I'm just trying to address your concern about your phone. Because a conversation with your attorney, that's privileged. He can't hear that.
I talk to because I can call my attorney, so I call my mom and I try to have her relay messages for me.
To your attorney. Okay, but you shouldn't be telling your mom something that you need to tell your attorney in private. The only thing you should be, because that's not privileged. Your conversation with your mom is not privileged information. When you call your mom, if you can't get in touch with your attorney by contacting him to have him call you on a private, secure area, you should only be telling your mom to have your attorney call you. If you start giving out information over a line, which they tell you is recorded, then you're giving out that information on your own.
Further, Your Honor, I have never seen it happen with the jail where they're not able to call their attorney, even when their phone privilege is being revoked. I'm not saying it couldn't possibly happen. I'm saying I've never seen it happen.
Ma'am, I recognize you're raising your hand, but I'm not sure why.
Off the record.
We're not off the record. We're on the record. That's why everything is under oath, on the record right now for official court proceeding. If you want to talk to your son's attorney, then you get his attention, but I can't let you just blurt something out in the middle of court that could potentially be harmful to you or your son.
Your Honor, I would look into the jail situation, see what's going on. It may have been something they switched into the new jail.
Right, it was you're given dates from February or March where the last calls.
He was able to make it from his own account in February. He then switched to the other inmates.
Yeah, it sounds like probably when they transitioned, something happened. I don't know what it was. I will restate my note in the updated order to make sure they are aware that you can make phone calls to your mom and obviously to your attorney, but your attorney's calls should be private. It shouldn't be made the same way that you're calling your mom. And I can't advise you as to what information you want to tell your mom over the phone. I can tell you that that is not a privileged conversation. And it tells you that the call is recorded when you call that number. And you have also seen in this courtroom at least multiple times that the prosecutors, contrary to what you may have believed in the past, do listen to the phone calls, okay? Any other questions? Your bond and file number 3029 was set at $100,000 cash surety. That will continue. Your bond and file number 3034, 300,000 cash surety. That will continue. Any additional matters for the record?
Here, I actually wanted to address bond file 223029. I would like it to be raised to be equal with the other file, 300,000, given what's been played before this court, and the fact that we heard that he has a history of contacting victims with this court.
And I would oppose that. I don't think it's necessary at this point.
I don't think it's necessary either. It's not been able to post it at this point. I don't think raising it's going to further the protection of the alleged victim. I think
Understood.
the concern obviously still is about jail calls and statements being made. It's been the concern at this point. But I don't think that increasing that bond to be 300,000 will add an additional layer of protection at this time.
Thank
Any
you,
additional
Tom.
matters?
No, yeah, thank
Nothing for the people.
Selena Luna?
Requesting transfer.
Selena Luna? You have to unmute, ma'am. Yeah. Ms. Luda, if you can't unmute, I'm gonna have to reset your matter for in person.
He paid you.